What's up, guys? It's Dark Angel here. Hey, so I'm dedicating this video to my troll, Fiddletown2002, and yeah, I'm calling you out, bud. I've had enough of your little antics and your little state cases that you keep trying to sling around, thinking that that's got power, and the Hendricks versus Maryland case, thinking that it's got power. And so this video is going to you, and just so you can see, I am actually reading from what I'm going to read to you is state authority that was issued. Okay, you see what that says right there? That says police authority. And then you flip the page, Fiddletown, it says state authority. What the state can and can't do, what the police can and can't do. This is their policy. Okay? And then there's the thing called the whole act rule. The thing that you seem to fail to understand how it is organized and how the system actually works, because apparently you don't have a clue. You sit there and you cite these cases and you got these little deals that you keep citing, but here's the thing. I go on your page, on your channel, and you have nothing on your channel, which tells me you're a fraud. Because if anything of what you said had any power or authority, surely you would have a channel where you would be making videos to contradict everything that's being said and everything that's being done. Surely you would be the guy who would want to step up and be that guy to debunk the right to travel. But apparently you have the know-how. You're one of those what I like to call media warriors. They like to talk a lot of crap behind the scenes because you're not man enough to stand up and come in front of the camera and be seen so that people know who you are, you know. So I'm going to take you back in a little bit of history, and I'm going to read some stuff for you that came. Now, this manuscript that I'm reading there, Fiddletown2002, this was sent to me. Apparently you don't watch my videos, so you don't remember this manuscript. This manuscript was sent to me by a Supreme Court judge. I didn't look this stuff up. I didn't go research it. This is stuff that was sent to me by a Supreme Court judge. It was put together by state prosecutors, United States prosecutors, I should say. Okay, on all three levels: state, federal, and Supreme Court. So this comes from all three levels. This isn't just one state Supreme Court. This is the United States Supreme Court. Okay? Yes, in the event that you're wondering and wonder why I am so confident in saying what I say, is because I have friends in these places. I've done 25 years in the United States Marine Corps. I have been stationed in some of the most prestigious places around, you know. So therefore, when I sit there and tell you what I'm telling you, I'm speaking on it from truth, facts. Everything that you've used, everything that you've said, everything that you've presented to me in your little debates and little arguments, none of it has authority. None of it has substance. None of it has meaning. It's all unconstitutional. Always has been, always will be. Sorry. If it had power, Fiddletown2002, the states would be using that against us to shut down any time someone would come forth with a right to travel argument. They would be using those cases against us, and they don't. We win every single time we go into the court. The cases are being dismissed. The cases are being dismissed in the best interest of justice. And you have to ask yourself, why would judges dismiss these cases in the best interest of justice? Because if anything you had to say pursuant to that of your opinion, if any of what you said was true, they wouldn't be dismissing it in the best interest of justice. based on the fact that they know that, hey, the public's figured it out. This hasn't been nothing but a big Ponzi scheme, and it's been a long-running Ponzi scheme since its induction into the system, and the people are just now waking up and realizing that, yeah, you've encroached upon our rights. So Fiddletown, this is for you, because I really do hope that you come on here and comment to what is being said, but just know this: anything that you say is your opinion. And anything that you're going to comment on is, again, your opinion. What I'm stating to you is straight from the courts. So you don't have nothing that can dispute what the courts say. You don't have anything. Just know that. So you're wasting your time with me, but just know that this is dedicated to Fiddletown2002. Okay? So, the Washington State Supreme Court has long-standing declared the difference of uses of automobiles not inconsistent with the breadth of this document. When taxi operators had their license suspended, they appealed claiming loss of liberty. The word particular in this exemplar ruling identifies a factual distinction between personal conduct and commerce. See, again, you're not understanding when I tell you personal private. Now, there is a such thing as a personal private individual operating in commerce, but what you're failing to understand is the word commerce. And you keep wanting to throw these cases up. Don't you know that anything before the 60s, anything before the 70s, anything before the 80s, even operating today, it was all known as commerce. And if you don't know what the definition of commerce is, the definition of commerce is it means to do business and or trade. So anyone operating a vehicle was required to have a license because they were obviously going to do business or trade. So since you didn't know that, now you know now. Because the DMV is only operated through commerce. That's all it's ever been operated under, was commerce. So, to keep going, because I'm going to make this short, sweet, and straight to the point, because like I said, I love you, Fiddletown2002. I don't even know who the hell you are, but to me it seems like you're a fraud. Because like I said, if you had any substance, any reality about yourself, your channel would actually... How do you have 5 subscribers and you don't have one post, one video, nothing? How do you have 5 subscribers? To what? You don't have nothing. You mean people are subscribing to you based on the dumb comments that you make because they're just as dumb as you are, ignorant as you are, whoever you are? I don't even know who you are, but I don't care. I'm going to tell you that right now, because nothing you say, can, or do will ever change my mindset. See, you're one of those ones who like to corrupt and keep people down because you're afraid of what the truth is. You can't handle the truth. As the old classic movie says, you can't handle the truth. And that's why you're stuck in your ways. Plausible deniability is what you believe in. So you'd rather deny everything based on the fact that you know it's the truth, but you don't want to be the one to have to admit to the truth. So with that being said, I'm going to continue because I want you to get this. I want you to know and understand this. You're talking about that not once have I ever mentioned any cases that actually say that a license, registration, insurance, and all that is not necessary. Well, guess what? Hang on to your big girl panties, because I'm getting ready to show you that you're wrong. There is plenty of Supreme Court cases that say that. None of those cases that you presented say what you said they said. I've looked them all up and I've read them, and that was your emphasis at it, your opinion. So I'm getting ready to give you facts. I'm getting ready to substantiate you with facts, because that's how this goes. This channel is about the truth. It's always been about the truth. So anyway, continuing on, the word particular in this example ruling identifies a factual distinction between personal conduct and commerce. And it even suggests that one may use a company vehicle for personal use when not commercially engaged. The court said this: the defendants are being prohibited from using a particular mode of travel in a particular way. State versus Shuffle, 82 WN 2D 872. Whoopsie, there goes one for you right there. The evident purpose of the ordinance was to regulate and supervise. Listen to this now. Remember when you was trying to list all those cases about how the state was allowed to do this, the state was allowed to do that? Well, here goes the regulation that was imposed to the state. The evident purpose of the ordinance was to regulate and supervise the business of public carriers of passengers upon the streets of the city for the convenience and safety of the public. The license is required when one engages in that business and not when he used a vehicle for his own personal accommodation. In your face, Fiddletown2002. It's law, baby. It's law. Hang on, I'm not done. In other words, the ordinance does not purport to regulate or supervise the mechanism of vehicles that are allowed to use the streets. It is only the business of public conveyance of vehicles of some kind that is subject to the supervision of the city. State versus Dunkley, 76, New Hampshire, 439, 83, ALT 40. Oopsie. You said you said that I don't ever supply you with case law. I've always supplied you with case law. You just don't take the time to read them because you're just, I guess, ignorant or something. I don't know. And whoever you got researching your law, you might want to get rid of them because they have no idea what they be looking up. I don't know what they're looking up. State cases, and you think that those state cases apply to all 48 states. State Supreme Court cases don't apply to all 48 states, you moron. Only the one United States Supreme Court applies to every state. Okay? Just in the event that you didn't know that, now you know. In proceedings to punish for a violation of the regulation, the burden is upon the prosecution to show that the defendant is within the terms of the regulation and has vacated it. City of Chicago versus Gall, 195, Illinois, appellant 41. Also see Huddy on Automobile 6th edition, 145. On the trial of a charge of violating a provision without a license, it is necessary to prove that the accused was plying for hire. What? What'd that say? What'd that say? Oh, as an example, the placement of an automobile on a public street where it is accessible to those who may wish to hire it, and the solicitation of passengers for hire by the one operating it by word act of exhibition of signs or devices. Huddy on Automobile 6th edition, 149. Again, all of this, what I'm telling you, supersedes everything you've said, everything you've ever wrote, and everything you've ever mentioned. This is the law that they use today. This is the standing law that they use today. Okay, Fiddletown2002, just know that. This is the law that they actually use today. This book right here is the reason why the right to travel is illegal. Okay? It's always been legal anyway, but you're ignorant, you don't know. So I'm going to enlighten you and educate you. In the early 20th century, the state of Washington has ruled that personal and private use of one's personal automobiles is perfectly legal and lawful. What? Wait a minute. Go back, let me reread that again because I want you to see that. In the early 20th century, the state of Washington has ruled that personal and private use of one's personal automobile is perfectly legal and lawful. It is only under the auspice of a violation of commercial licensing statute policies that it could be said one has committed a traffic crime. Traffic is a commercial term, by the way, in the event that you did not know that. The state would have to act in bad faith to rule personal use of public highways lawful, and then with surreptitiously spurious intent dare to bring a criminal violation of a policy which offers no jurisdiction, no redress, and no authority over lawful conduct. Straight from the Supreme Court. Wow. Straight from the Supreme Court, people. And that's a case that was argued here in Washington. And let me tell you something about the Port versus Washington case that you keep bringing up. That case has no authority, brother, sister, whoever you are. Fiddletown2002. Port, in her brief, legally gave the state authority to do something that the state had no authority to do in the first place. Okay? She took the license and renamed it as a certificate of compliance, that the state should have some authority, is what she said. That was the reason why she lost her case. Had she not given the state that authority to rename that license and issue that certificate of compliance. Now you might want to go in the case and actually read that, because it is actually in the case, because I have that case here and I made a video on that case. So how you are sitting there citing that case tells me that you're citing this case and you haven't even watched the video of where I did the reading on that case. Okay, the only reason why Miss Port lost that case is the fact that she gave the license a different name. That's all. That's the only reason why she lost. Not because of some rules. The court only used what they had in play. Had Miss Port went forward and utilized the Chicago Motor Coach versus the City of Chicago case, where it actually says no government has the authority to issue a license in all this, she would have won that case. She would have won, and that case would have set precedence. We don't need her case, because her case has no authority, because she gave them authority. But that is not standing law, okay, even though you used it in one of your arguments towards me. So that case has no authority. What I'm reading to you has precedence over all of it. Oh, and by the way, the Haynes versus Henkel case, yeah, you might want to go back and read that case, because I don't know what that comment was you made about how that case doesn't do this, that case doesn't do that. That case has been sent to the Supreme Court 1,600 times since 1906 and has never been overturned or never been superseded. So therefore, I don't know what your comment was. I'm assuming it was just your ignorance in opinion that you issued, that you offered, and that it was just an ignorant opinion that you set forth. But as a matter of fact, yeah, that's exactly what I'm going to call it. It was your ignorant opinion, because you apparently don't understand that the Constitution even says, and I do believe it's in the 9th, 10th, or the 11th amendments of the Constitution, that the state has no authority over that of private affairs of private individuals. Also, for your information, because you obviously didn't know this either, a license is a title of nobility. The title of nobility is calling you a driver. And if you don't know what title of nobility means, you might want to look that up and do some research on that. Because of the simple fact is, a title of nobility allows people to have privileges that some people are not entitled to. And the reason why I'm saying that is because I'm going to point this out to you. Not everybody can walk into the DMV and have the required book smarts to sit down, take the test, the writing part of the test, and be able to pass that test. So no, it is not afforded to everybody, because not everybody is on the same IQ level. Everybody has different IQ levels, because each individual is independent to themselves. So therefore, you have two people walk in, one can take the test and gets it passed at 99 or 100, but the other person only gets a 56. But that person that got the 56 can actually operate that vehicle better than the person that got the 100. Doesn't necessarily mean that that individual is not smart. They're just more of a hands-on type person. And being a hands-on type person should not due to the handwritten aspect of a test that means nothing in the first place, prohibit them from being able to drive just because they're not as book smart. Now, they can read, they can write. Their comprehension just might not be as high. So that deprives them of the right, as you, only you, put it, the right to drive. Okay? The right to drive is not a right, brother. It's a privilege. That is the privilege. The difference between that and travel is a right. Always has been since the Magna Carta. And if you don't understand what the Magna Carta is, go do some research on the Magna Carta. That's how far back this goes. This goes back before you was even thought of, before I was thought of. So, I mean, you're sitting there putting stuff out there that means nothing to nobody. I mean, it sounds good when you look at it and then when you read it, but then one thing that we of the know do know is that when you start expressing words that you have no idea what they mean, I just gave you the definition of what driver is, and this is as of 2023 of what they define driver as. Because here's the thing, the police want to tell you that driver means anyone who, let me find that again because I want to make sure you know. Okay, so one thing you need to know is the term motor vehicle is not necessarily synonymous with the term automobile, meaning they don't have no similarities. They do have similarities, but they're not necessarily similar in that of the act of law. Whoops. Okay, so that's just for your own personal business because you don't know. Personal use of a personal property automobile is not schematically representative of a governmentally regulated activity. Did you hear that? AM Juror, second automobile, section 2. Motor vehicle is a broad term that has no universally accepted meaning. It has been considered to be much broader than the word automobile and to include various vehicles which cannot be classified as automobiles. Whoopsie. Again, this right here, this book right here, buddy, this book, yeah, this manuscript right here that you're looking at that you hate so much because you didn't even know it exists, yeah, straight from the Supreme Court. Straight from the Supreme Court justices, you moron. Yeah, I'm picking on you, bud, because I really like you, though. I really do. I like your audacity to keep trying to corrupt the minds that are already free and try to corrupt the people who already are in the know. I love that. I like the fact that you try, though. An automobile may be purchased from an automobile dealership or a private party when such automobile is proffered for sale. And yet the purchase of the automobile itself does not trigger a commercial kinship. The dealership did not proffer for sale a motor vehicle as defined by statute. As stated by the Dunkley Court, infra, it is not the possession of the vehicle that is subject to regulation, rather it is the intended use. Personal use of the personal property automobile is not schematically representative of governmentally regulated activity merely because one may use it on the common highways. The definition of motor vehicle found in both the federal regulation and those of the state of Washington are strictly construed and confined to the use of an automobile in a commercial aspect, meaning the remuneration for services. The word automobile expresses its own meaning, and generally it is to be taken and understood in its ordinary and proper sense. Whoops. AM Juror 2D Automobile Section 1. Also see Huddy Automobile Law 9th edition ninth edition, definitions and distinctions. Judges have the general cognizance of other people as to the terms relating to the use of automobiles. Huddy Automobile Law, ninth edition, definitions and distinctions 7, citing Chamberlain's Modern Law of Evidence. Like I said, all of this comes straight from the Supreme Court, bud. You don't have no argument. I don't even know how you can even stand yourself. You know, all my followers and everybody that follows my channel, they've seen this book. I've showed them this book. I've done videos on this book right here. That's why I have the all power, all knowing. I have the power. I have the all knowing. Because I'm telling you stuff that you've never even heard of. A motor vehicle must have been designed for use and or used to transport persons and property over the public highways. AM Juris 2D, Automobiles 2nd. Law of the land, by the way. Never superseded, never overturned. In pleading, however, especially in criminal proceedings, particular care should be exercised in using the proper and correct terms, especially when the definitions to be found in a statute which should be followed in the language of the act. Meaning, if it says motor vehicle, not automobile, if it says motor vehicle, a statute, the rule that applies there is that which does not include something excludes all others. Meaning that since the statute only defers to motor vehicles, a commercial vehicle, it excludes automobiles. Now that you know how that works, that is the process, that is the procedure that they use in determining statutes. And if you read the statutes, just like they do on the RCWs here and the WACs here in Washington, they even specifically state in the statute, at the very end of the statutes, they specifically state that the statutes are to be taken in that of their literal sense. So, with that being said, the inclusion of one excludes all others. That's the literal sense. You only mentioned motor vehicles. Nowhere in the statute does it say private automobiles. Nowhere in any statute does it say that. So, there's that for you. Hope you learned something. All that little stuff you wanted to sit there and talk about, it's actually kind of interesting that you would talk about that stuff, but unfortunately for you, you have no idea what you're talking about. So, crimes are not to be created by inference. They may not be constructed nunc-pro-tunc. Ordinarily, citizens may not be punished for actions undertaken in good faith reliance upon authoritative assurances that punishments will not attach. As this court said in Raleigh v. Ohio, 360 U.S. 423, 438. Here's one of the cases you like to use. This is one of the cases you actually cited to me. And this is said within that same case that you took that little exertion that you said. We may not convict a citizen for exercising a privilege which the state clearly had told him was available to him. As Raleigh emphasized, criminal sanctions are not supportable if they are to be imposed under vague and undefined commands. I'm not even sure if you understood what that means, but he's exercising a right, a privilege under a right. And certainly not if the government's conduct constitutes active misleading contracts. Whoopsie, there it is. That's in the case that you cited to me, bud. That's in that case, the footnotes. You know, you probably get the cases and you don't even get the footnotes, so you actually don't have a true understanding of what you're reading. You read what you say and you think, oh, that's it, that's the power. Well, no, the footnotes is the power, because the footnotes is what supports the opinion of the case. And that right there just pretty much says, 16 American Jurisprudence 2D Constitutional Law 576. from the cases you cited. Meaning that if the government initiated a contract that did not give clear understanding as to full disclosure as to what that contract is, you don't have to uphold your end of that deal, that contract. You don't have to. It's not required, because that's failure to disclose full disclosure of the contract within itself. That's a given. That's with any contract. That's not just with that. Just with driving or traveling. That's not with that. That's with any contract. You go into a contract agreement with anyone and you don't get full disclosure as to the terms, conditions, and whatnot, okay, then, you know, hey, you don't have to uphold that end of that contract. So going on, because now what I'm getting ready to read to you now is from the Attorney General. This is from the Attorney General Office, 61-62, number 46. And this is just the edited version that they put in this book, because of the simple fact the actual opinion was too long to publish. And this book was only mandated to be published at so many pages. So what he says is, a special note here is that the legislative policy has the blessing of the judiciary. The judicial blessings are supportive that the legislative policy is and only commercial in nature. You know, those regulations that you keep wanting to talk about, where the state has the right to regulate its commerce, you know, its right to travel. The Attorney General just put it there in your face and told you it's only commercial in nature. It doesn't have any support or any standing on any other level, just the commercial level. He just said it right there in his opening statement in his opinion. So let me go on and finish reading this. This leaves only the executive branch of the government to be reined and bridled as to their enforcement of interpretive presumption, noting, of course, the executive does not have the authority to interpret statutes. What? Neither can they presume the statute to mean anything more or less than its intent. I was just sitting there and I just explained that to you. I just said that before I even read that. I just told you that. That which is not included excludes all others. Therefore, meaning that since the statute only talks about motor vehicles, which we already know a motor vehicle is a commercial vehicle, okay? Nowhere on its face or nowhere in its body does the statutes mention personal private automobile. So therefore, just as he has said in his opinion, everything else is excluded. Now, you go register your car, it automatically becomes a commercial automobile. It automatically becomes a commercial vehicle. It automatically becomes a commercial motor vehicle. And what it does is, when you do buy that automobile, is that case that I was reading to you where it says about you buying a vehicle from the dealership, okay, once you go register it, your automobile gets reclassified. It gets reclassified as a motor vehicle to operate in commerce. Now, I'm not understanding which part of that you're not understanding, but this is real law. This isn't no made up bullshit. This isn't none of that bullshit. This is real law. This is the law. And this is the reason why, when we go into the courts, why we win these cases is because of what's in this book right here. Because all that little bullshit you keep trying to name, no state has ever won a case against any one of us for filing this. And you say, oh yeah, there's plenty. Okay, but have you seen the appeals yet? Bet you haven't. Bet you haven't seen any of the appeals of those cases yet. Because I promise you 100% that if they argue it right, those cases will win in court. And the bottom line is, what did it say? What did the part of the deal say? It is to be taken to its literal sense. So therefore, even if you're acting under pro se, Okay, keep this in mind, and this message goes to everybody. Even if you're acting under pro se, if your wording is not direct, okay, and we'll just say, I'll just use the expression, you accidentally allude to something else within that of your writings, that's how the court's going to take it. They're going to take it that you actually meant whatever it was that your argument alluded to. For instance, like in the Potts case, the Port case, I'm sorry, not Potts. In the Port case, she was on point through her whole argument about driving without a license. She was on point. She had it until she gave the state some authority to issue a certificate of compliance, which in turn, all she did was take the driver's license and give it a different name. That's all she did. She took the driver's license in her brief and gave it a different name, continuously giving the state authority, okay, to regulate her right to travel, okay, and steal her rights away from her. So by her having done that, and the only way that rights can be taken away is if you knowingly, voluntarily surrender them, and or you take it in front of the legislation under a House bill and it gets voted on. Such as, let me give you a prime example of what I'm talking about, and I'm going to give you another I'm going to give you an example of what I'm talking about, and then I'm going to give you another example of what I'm talking about. New Mexico governor. Okay? She is under the assumption that because she is the governor of the state of New Mexico, that she has the power and authority, okay, to deprive everyone of their rights. Now, she's trying to explain it as, it's not a ban per se, it's just a pause. You can put any name on it you want. Ban, pause, timeout, whatever. If it is in relation to prohibiting an individual from being able to exercise a right, it's unconstitutional, no matter what name you put on it. If it is something that is prohibiting an individual from being able to exercise their right, the name that you attach to it does not matter. The cause that you attach to it. Now, she says that the reason why is for public health reasons, for public health and safety. Well, lucky for us, the Supreme Court said that's not acceptable. Public health safety, that's not acceptable. That's not a legitimate reason, because of the simple fact, gun violence is going to happen regardless. So that health safety issue ain't going to work. That public health safety issue, especially when you have her own sheriff, the sheriffs in her state, the police chiefs in her state, and the other governors or the other senators and what have you in her state saying there is no public health issue, because it's not considered a public health issue. You know, and the public's health is going to either excel or decline regardless as to what type of ban or what type of permission you put on it. A right is a right. You can't regulate rights. You can't license rights. You can't put a fee on rights. You know, they keep talking about, oh, if you lawfully possess a handgun. When criminals was let out of the jails back in the day, back in the 1800s, back in the Western days, I'll say, they were given two things: a horse and guns, and their sidearm. That's what they called them back then, sidearms. Criminals being released from jail or prison, That's what they were given. A sidearm and a horse. You served your time, you're not considered a criminal. You may be an ex-criminal, but it's discriminatory to hold a person to crimes of the past. It's discriminative. But no one has the audacity or the balls to actually challenge that. You know, they lawful. Who are you to determine what's lawful? Because just because I committed a felony act in my past does not mean that you have the right to regulate my rights. I didn't surrender my rights. I surrendered my rights at the time I did the crime. And at the time I did the time, I surrendered my rights. Nowhere in the Constitution does it say that once you commit a crime, your crimes are indefinite and your rights are to be taken away indefinitely. Nowhere does it say that. It doesn't have a time limit on it. And nowhere in the Constitution does it say that I should have to reapply to have my rights reinstated. My rights weren't given to me by man. My rights were given to me by God. God gave me the right to defend myself. God gave me the right to travel around this earth that he created, not man. Man can't tell me where I can and can't go. Man can't tell me that I can and can't defend myself. Period. Man thinks he can because he was given a little authority by another man. I'm not under your authority. You don't tell me where I can and can't go, what I can and can't do. You don't tell me how I can and can't defend myself. You don't tell me how I can and can't travel. You have no authority over that. The right to travel, as you saw what he said here, what the Attorney General has stated here, the Attorney General's opinion means just as much as the Supreme Court's opinion, in the event that you don't know, because this is the United States Attorney General. In the event that you didn't know, this book was written by them, the Supreme Court, and the United States prosecutors. So I have my facts straight from the horse's mouth. You have your facts straight from an opinion that you generated, and the fact that you do not know how to actually comprehend and cite law. You're sitting there trying to point out to me that that I'm misinterpreting the law. I'm not misinterpreting the law, brother. Not to any degree of the word. I haven't misinterpreted one case that I've ever presented in a video. I've actually interpreted pursuant to that of the footnotes that were expressed on the case. And that's what matters. Because the footnotes is the power to the opinion. And that's something you're not understanding. You have your opinion. You're entitled to it. But what you're not entitled to do is try to brainwash people into believing your ways. Your ways are unconstitutional, which makes you a troll. It makes you a hater and a traitor of the Constitution. You don't have no right to try to convince me to walk on your side when I'm trying to educate people and let them see what the truth is about the Constitution. The government wants to quickly call everyone who stands on their rights anti-government. Domestic terrorists. How is that possible? The government, the courts, passed laws that support constitutional rights that's supported by the Constitution, and we, the sovereign, have decided to stand on our rights. And I get why they call us anti-government, because it's not because we're going against the government. It's not. The reason why they call us anti-government is because we are standing on rights that God gave us and not man. That's why they call us anti-government. That's a fact. It's the only reason. We're not going against the government. We're just standing on God-given rights. And we're utilizing law that the government set forth. So you say, well, that's anti-government. Okay, call it whatever you want. You know, But the fact of the matter is the government's against itself. Because of the simple fact is, you was given that power, but no one ever gave you the power to act against inherent rights. Whoopsie. No one ever invested you with that power, the government, that you can go up against inherent rights, rights that were established before you ever was. The government's fictitious. It's made up. It's made by man. You know, and you have a lot of people who would say, well, God's made up. If that's your belief, you have a right to believe what you want to believe. You know, you can say God's made up. You can say he's real. But apparently he was real if you look at the history of the United States of America, because of the simple fact is he was inducted into schools. You still have what they call the Bible belts of the United States. So apparently he must be more real than what one person's opinion of him not being real is, because of the simple fact is you still have hundreds of millions of people who believe that God is existing. And those hundreds of millions of people's opinions fare over one person's. Just saying. Just saying. So let me continue with this, because I want to make sure that you get and understand something. So, here you go right here. So, here we're getting ready to talk about the Department of Licensing and the DMV. What the Attorney General says. And again, you can find this in AGO 61-62 number 46. Go online or go to the library and look this up, because here it is right here. The following is former Attorney General John J. O'Connell's opinion as to the intent and application of the operator and driver's license. Mr. O'Connell, as a former representative of the state of Washington, agrees that all statutes relating to operating and driving are static, as well as confirming that all license issued by that of the Department of License and or the DMV are in fact issued for higher status. And by the term, here we go. Again, what I was just telling you, that which is not included is excluded. Here's what he says. All statutes fall under use of the Latin legal maximum expressio unius estes exclusio alteris. Oops. In other words, what that means is he acknowledges that no license may issue for personal use of an automobile. No license may be issued to anyone for the use of a personal automobile. That which is not included is excluded from the statutes. All statutes are commercial, bud. Right there. Oh, and by the way, that's standing law. That's why you never win. That's why your opinion means nothing. That's why everybody laughs at you when I go on the other sites and I see you making the comments and everybody's laughing at you because of the things you say. It's because you're not in the know. You don't have facts. You have old law that means nothing to nobody. That's why nobody ever cites those cases that you've been going in there looking for. Nobody needs to know those negative laws, those negative cases. They have no reflection or bearing on anything, brother. This is law right here, what I'm reading from. This is law. The Supreme Court, the United States Supreme Court, they put this book together. They made this. This is their book. They made this book. Yeah, they put this book together. Look at that. It even says right there. Look at that. Credits and resources of everybody involved in the book, in the making of this book. Look at that. Look at that. There. Yeah, it's upside down, but it's okay because I'm showing it to you upside down. But this is all the Supreme Court judges, all the prosecutors, everything that's presented in this book. Oh, look at this. The federal preemption, due process, police authority, municipal regulations, the whole act rules, statute and history, taxation, constitutional charter and authority, undergoing the contract. Oh man, what you got, bro? What you got? Driving, licensing, anatomy of traffic infraction, the tort liability, public disclosure. What? What do you got? You don't have nothing. You can't, everything you said, you don't have no proof. But I have all the structure of everything that's ever been written. Everything. I even have those case laws that you have. Hence the reason why I never mentioned any of them, because they're not worth anything. They have no value. Nothing you've argued has any merit. Never has, never will be. Maybe at one time before other people started arguing other cases, they might have had some standing. But until 1906, when the Haynes versus Hinkle case came out, any case in relation to the state's authority as to where commerce was standing, that's where it came from. That case has never been superseded, never overturned, brother. Never. And as he says, he acknowledges that no license may issue for personal use of an automobile. Right there in the words. You said that I never provide you with anything. I just gave you the words of an attorney general. Yep, just gave you the words of an attorney general. And actually, his opinion, they put the majority of it in here, which is actually quite a few pages long. Yeah, and you know what's so interesting is he's actually referencing in here the RCW 46.01.10 RCW about licensing that the police actually use today, right now. The same one that has not been amended. He's actually referencing that RCW that I just, matter of fact, just went and got the entire book and chapter on. I've had parts of the chapter, but I do now have the actual chapter in which he is referencing. And any officer who pulls you over and decides to issue you a ticket under that is in violation of the Constitution. 100%. And that's one thing that the courts never explained to the officers, is because under the that which does not include others excludes all others rule, that the statutes are held by. Okay, I don't know why my camera's all blurry, but okay, that which the statutes are held by, that rule, that maximum rule, from the Latin sense, nowhere in that statute does it include that in it. You know, automobile, I'm sorry. Nowhere in the statute does it include the word automobile. And then, in fact, if you go down in the statutes to 4625, it actually says in order to operate a motor vehicle, one must have a valid CDL under section 4620, which under 4620 it states in there that in order to drive on the highways in the street, one must have a valid driver's license issued to them under 4620. But nowhere in 4620 does it state that a driver's license is issued. Okay, that what is being said, that's just a statement. Okay, but when you look up the statute 4620, there's nothing in there telling you about a driver's license. There's nothing in there telling you about the gross vehicle weight, the weight of the vehicle or anything of that magnitude. There's nothing in there telling you that. But when you go down to 4625, all of a sudden the vehicular weights and everything is mentioned. And get this, none of them are under 10,000 pounds. Yeah, it's in the statutes, brother. You need to read that. So what I'm going to do for you is I'm going to go ahead here and show you the state's authority to regulate. The state only has the authority to license and regulate business. Business is commerce. Commerce is sale and purchase, bought and sold with, of course, the static delivery, shipment. The driver's license issued after 1968 is in fact a proprietary operator license with a secondary driver aspect. This can be identified at RCW 4601.040, which is what I was just talking about. That's why and how the policy enforcement employees are able to randomly interfere with the public at large through lack of notice. The policy that is so deliriously fragmented that a man of average intelligence could not understand it to be anything other than what is facially posted. Imagine that. The constitutional right of every person to pursue a business, occupation, and/or profession as a paramount right is subject to government regulation and restriction, and as such is subject to reasonable use of police power. If a business itself is a proper subject of police regulations, so are all of its incidents and accessories, such as the manner of conducting the business. 16A American Jurisprudence, Second Constitutional Law 372, and that is the actual law that gave the state the right to regulate. That is the actual written law. That is the law that gave the state the power to regulate, right there. In the event that you didn't know. Nowhere in that law did it say it had the right to regulate private travel. It gave the state the right to regulate business. You drive in business, you have to be regulated. Period. Sorry, bud. Like I said, you have nothing. I have the all power. I am the all-knowing dark angel. I know. I know it for a fact. That's why I do what I do, and I've been doing it for 30 years. I've been doing it for a long time, brother. And for you to sit there and try to tell me what? No. Under the inherent police powers, the state has the right to regulate any and all kinds of businesses in order to protect the public health, morals, and welfare of its people, subject to the restrictions of reasonable classification. The highways of a state are public property, the primary and preferred use of which is for private purposes. Their use for purposes of gain may generally be prohibited by the legislator. Stevenson versus Benford Supra. The highways is actually for use of private use. Case hasn't been superseded or overturned. As shown above, where the intent of a statute or the execution of a statute must be determined by referring to other parts of a statute or a separate statute altogether, one must invoke the whole act rule, as the separate chapters and separate statutes must be read in a para materia, which means a whole. In other words, throughout the whole statute it reads motor vehicle. Does not include automobile. Sorry. So, keep going. The state nonetheless is endowed with the authority to suspend or revoke a license for careless or negligent operation. However, as clarified earlier and hereunder, the loss of a license to operate a business does not disable a man's use of the same, if appropriate, automobile for his personal affairs. In the Shuffle case, the court reasons a particular use of a particular way which is prohibited. The Shuffle court, not inconsistent with the Stevenson court, have each susceptibly denominated the separate and distinct nature of operating and driving for hire as against the personal use of an automobile. Whoopsie! Two distinct areas: driving, operating, business, traveling in an automobile. Different. You said I never supply you with cases. Here you go. I'm giving you cases. Power cases that you can't even fuck with. Because you're just that ignorant. Fiddletown2002. The revocation of a motor vehicle operator's permit is within the ambient of the state's police power. Power to protect the public from reckless or negligent operators. The government interest involved in that of the protection of the individuals who use the highways. The Act, RCW 4665, calls for the revocation of the privilege of operating a vehicle where one has demonstrated his total and complete disregard for traffic safety of others. The defendants are being prohibited from using a particular mode of travel in a particular way. State versus Shuffle. 82 WN 2D 872. I've already read that one for you already. In other words, if they want to use it as their own personal private automobile, their business automobile, they can do that. And they don't need a license to do that. You could suspend their license and they can take that vehicle and utilize it. Purpose of intent. See, you can go down to your county records office and file your car with the county clerk under that, and it would be in reference to that of your purpose of intent. Come on in, honey. And you can come in, babe.
I don't want to be on the video.
Oh, okay. Sorry.
Okay.
And you can file it with the county clerk's records office, okay? And as long as you file an affidavit of intent as to what that automobile is going to be utilized for, the police have no issues. They can't have no issues. Because of the simple fact is, your intent is publicized with the county clerk. Dinner. Yeah. Dark Angel's got some dinner on the table. So, that means this video is going to get ready to be cut short because Dark Angel is getting ready to engage in some nice, tasty, homemade lasagna. But I kind of want to keep going on this for a minute because I want to actually get to a case, hopefully that I can find it real quick here. Oh, hell, here you go. Here we go. I'm actually going to read this for you because this right here okay, so yeah, here's what I want to read to you. To interstate commerce. Here again, notice that this definition incorporating the term carrier refers to one conducting business. No mention is made of one who is traveling in his personal private automobile. This definition is one who is engaged in the passing of a commodity or goods in, did you hear that one, that before I said that, personal private automobile? No mention of it. Imagine that. Exchange for money. Vehicles for hire. Furthermore, the words traffic and travel must have different meanings, which the courts recognize the difference. And the difference is recognized in ex parte Dickey Supra stating, in addition to this, cabs, hackney coaches, omnibuses, taxi cabs, hacks, when unnecessary numerous, interfere with the ordinary traffic and travel and obstructs them. And that's written straight from the Interstate Commerce Commission versus Brimson. Whoops. The court, by using both terms, signified its recognition of a distinction between the two, but what was the distinction? We have already defined both terms, but to clear up any doubt, the word traffic is manifestly used here in secondary sense and has reference to the business of transportation, rather than to its primary meaning of interchange of commodities. Allen versus the City of Bellingham, 95, Washington 2, 12, 163 p. 18. Here, the Supreme Court of the state of Washington has defined the word traffic in either its primary or secondary sense in reference to business and not to mere travel. So it is clear that the term traffic is business related, and therefore it is a privilege. The net result being that traffic is brought under the police power of the legislator. The term has no application to one who is not using the roads as a place of business. Damn, Fiddletown2002. I bet you feeling really dumb right about now, aren't you? Whoever you are. And you know what, Fiddletown2002, I actually hope that you're like a cop or something. I actually hope that you're a cop or some kind of government official. Somebody who would actually, somebody who can actually make an impact in that world. I hope that you're one of them, because now you're hearing straight from the Supreme Court, the Supreme Courts of the states, the Supreme Court of the United States of America. The Supreme Court of the United States of America even validated that what I just read to you. They actually confirmed that in a few cases. And as a matter of fact, they actually confirmed that in 48 different cases. Exactly what I just told you. You don't need a license to travel on the highways. Traffic is in relation to doing business. That's what traffic is. That's what the term traffic means, to do business. Especially here in the state of Washington, which is standing law today, to this day, to right now. It is it's never been changed right here in the state of Washington. But you do have police that will challenge it and go up against it, just like the governor went up against the Second Amendment. But look what happened to her. She got a temporary restraining order placed on her for acting against the Constitution. Now, can you imagine when a cop pulls you over and you're lawfully traveling? Okay? You're lawfully traveling. Why do you think all these lawsuits are coming? Because it's lawful. It's always been lawful. It's a fundamental right that is protected by the 5th and 14th Amendments of the United States Constitution. Just because you don't understand it and you don't know how to execute it doesn't make it not lawful. It's lawful. It's 100. Guaranteed. 100. And then the interesting part of what I want to show you is, here you go right here. So the case of Chicago versus Banker, okay, turned upon the questions whether the city of Chicago had the power by ordinance and in the absence of statute to require an automobile owner to submit to an examination and to take out a license before he should be permitted to operate his vehicle for his private and personal pleasure. The court, in declaring the ordinance void, held that in as much as there was no statutory provisions on the subject, meaning the state doesn't have no jurisdiction over a private individual. And that's what I've been trying to tell you, you dummy. The state doesn't have jurisdiction over a private individual. They never had. No state of the 50 states, no state's ever had jurisdiction over it. And here the city of Chicago just confirmed it. Don't no state have jurisdiction over a private individual. They're private property. They're nothing. They don't have no jurisdiction. Provision on the subject. The charter of the corporation is the measure of its powers. In other words, hey, if you decide to register your car, the corporation has jurisdiction. And the enumeration of those powers implies the exclusion of all others. As I said, and that right there, what I was first reading you about that which includes one thing but excludes all others, that is the rule that's used in Washington. Well, now you just see that's actually the rule that's used in the entire United States, because this case is a Chicago case. They're using that exact same rule. So that rule is applied by that, is actually implemented by that of the Supreme Court, okay, which is the overall rule that the judicial system uses. The whole act rule. And that's something that you're not understanding. That little, whatever that was, that little scenario thing that you kept wanting to try to insist on putting on me, that right there, that's not how the courts work. That's not how they operate. None of that what you said is how the courts operate whatsoever in the real world. In your delusion mind of a world, that's how they operate. Exactly what you wrote. Because that's what people like you want it to be. But that's not how it really works. This right here is 100. This right here is 100. This is how the courts work. This is what the courts are held by. And this is all courts, from the Supreme Court all the way down to the state court. All courts are held by this standard. That which is not included is excluded. The whole act rule. The whole act law. No tax is to be added to that of a personal private automobile. My. Oh, wait a minute. Hang on, here we go. In the case of Shreveport, below, the city brought an action against Stringfellow for the payment of taxes on his automobile. The city's claim for taxes was denied by the court because Stringfellow only had personal automobiles that were for his family's use, not for access to or by the public. Galvanizing that no taxes may be levied against, and consequently no policy enforcement may be laid against a private traveler. What? Oh my goodness. His automobiles were only used for private travel. State couldn't tax him. State couldn't force him to get licensed. State couldn't force him to get plates or insurance. That was what you was telling me, that I could never provide you with a case that said that. There you go. There's one. Actually, I've provided you with several, but knowing you, you probably ain't going to look them up. So, in the case at bar, a license tax is sought to be collected from the defendant, not on account of his calling or vocation, but because he is the owner of 2 motor cars used by him for the convenience of himself and family. And the court denied it, saying, nope, it's his own personal cars, you can't do it, sorry. Whoopsie. Man, that's something, man. I mean, I know that you wish you could, contradict what I'm saying, but you can't. You can't contradict what I'm saying because you don't have nothing, as I told you before. The state has no jurisdiction over a private traveler. Oh, here we go. Now, the jurisdictional branch is a co-conspirator in the initial legislative, subsequently executive licensing scam. Private travelers run the risk of being stopped and harassed for not, I hope you're listening to this, because there's no such statute that governs a personal private automobile. There's no statute that governs a private individual. That's why this was wrote in this book. Traveling, having license plates on their personal property, automobiles, and or a driver's license, but by what authority? Clearly the state has no authority or jurisdiction concerning private affairs. This writing goes back 100 years to get resolution as to the licensing scheme. The fact that the police use commercial licensing statutes to interfere with personal affairs is clearly inconsistent with the history of and interpret of the driver's license. Did you hear what that just said? The police use commercial statutes. All state statutes are commercial. Always has been, always will be. Oh, and you can find that in a few cases actually, but I'm not even going to sit here and name all the cases because it has 1, 2, 3, 4, 5, 6, 7, 8, 9. Oh, too many to count. There's too many cases supporting that. Just so you know, too many cases. Okay, so basically, you know, because of the fact that there is no statute that was ever written, no policy ever written on that of private individuals, their private affairs, their private automobiles, you file a motion to void for vagueness because the statutes are vague in their writing. Lack of subject matter, no policy, no statute written, no law can be enforced, no jurisdiction exists. Simple. That's how that works, bud. In the event that you didn't know, that's real-time law. That's real law. Not fake law. They always say, well, common law versus real law. Common law is the real law. It's the law of the land. Any other law made after that is man's law. It's fictitious law. Common law is the law of the land. Real law. Everybody's trying to switch that around and say, well, common law is not real. Yeah, it is. Because if it wasn't real, the United States wouldn't recognize it, period. There's that. So, with that being said, I'm going to go ahead and cut that short because my food's getting cold, and my food and my eating is way more important than sitting up here trying to prove to you, Fiddletown, something that you know nothing about. So, Fiddletown2000. Again, state has no authority to regulate personal private automobiles and or tell them how they can or cannot travel on the road. No such thing. I just proved it to you. And then again, as I said, this came straight from Supreme Court. Right out of their handbook. Yeah, Supreme Court Justice sent me this, by the way, in the event that you're wondering. Supreme Court Justice. One of 4 of which I do know personally myself, that I have met, talked to, sat down with, had discussions with. States Attorney Generals, the United States Attorney General. Yeah. That's why in 30 years that I've been doing this, I've only had 4 tickets, and all of them have been dismissed without prejudice, without incident. You know, but I do know that tyrants are born every day. Tyrants make themselves present every day. I know, and eventually it's going to happen. And I'm going to be rich. Simple. Because yes, I have the power to contract. So when that day happens, which I'm hoping that is pretty soon, because I'm getting too old and I do need a lot of money to take care of my daughter once I pass along, and I want to make sure that she's well taken care of, and my wife, because my wife's younger than me. So, you know, I'm hoping and praying that that happens one day. And it will. I'm almost certain it will. But if the police were smart, they would get educated. Whoever you are, Fiddletown, again, I believe that you are some form of law enforcement. And you're either some form of law enforcement or you're some unknown attorney who thinks he knows the law, when obviously you don't. But, you know, I'm going to give you the benefit of the doubt and say that maybe you're law enforcement who is calling yourself trying to detour channels like this. You would never do it. It's going to take more than you. The FBI could walk in here and tell me to shut it down. I wouldn't shut it down. They can threaten me. They can do whatever they want. They can come in here and try to deter me from telling the truth. But the video about Woodrow Wilson and what the truth really is has already been published. I published it already. It's out there. Not a lot of people are actually reading it and watching it and all that, but they need to hear what is coming straight from off his desk. What you guys need to know and understand about what the government and how they think about you as a whole. They think you're cattle, you're property, you're security interest. That one video that just came out where that cop ran over that young lady in the crosswalk. He actually said on camera, cut her $11,000 check. She was 26. She wasn't worth much. She didn't have much value. That's exactly how the government thinks about you. And that's on camera. From a police officer's mouth to the camera. Your life ain't worth nothing. That's basically what they're saying. You don't matter. As long as they have the authority, you don't matter. They want to take your guns away but give them guns. Psychopaths, tyrants, people of this magnitude. They want to give people like that guns. But they want to give decent citizens, they want to take away guns from decent citizens. And citizens in general. Because the Constitution doesn't regulate who can and can't carry guns. It's a natural right. It's a common law right. And therefore, when people start arguing that, and they see, because they have all these, you have all these new YouTube videos on there how you can restore your gun rights. You don't have to restore your gun rights, people. Your gun rights are God-given. Your right to defend yourself is God-given. Fuck what a man says. I don't give a fuck what they tell you in court. You can go to court and you can beat that all day, every day. People think, oh no, you can't because they're charging you and sending you back to prison, felon with a gun. Yeah, under unconstitutional law. But the point is no one's arguing it. No one's going up against it. No one's challenging it. There's no such thing as unconstitutional, as constitutional felons with a gun. Man wasn't never given the authority to regulate a God-given right. Man was never given that authority. Show me a law where it says that. Go into court and argue it that way, I promise you. They'll lose. They could bring up all the excuses. They can bring up all the reasons why and what have you. Unless you can show me one case that gave man authority to regulate a God-given right, you got nothing. So with that being said, Fiddletown, deuces.